So we're talking about when can a contract dispute go to court? And really, we're talking about the limits of human imagination. It's like, how many things can a human being think of to be in disagreement with another human being? And so when we're talking about what is a contract that can go to court, first of all, you have to say, what's an enforceable contract? And you might be surprised to learn that anytime in a business setting, when one person is making a promise to another, a contract is probably being created. So you have verbal contracts. It's just someone saying, shaking your hand and saying, I promise to build your house, under $1 million, like you described. And that can be a contract. Nobody will know what that meant. Mind you, when you go to court, then there are going to be all kinds of questions about what kind of house it was, and when the payment was going to be, when, there's going to be a lot of questions, but you probably have created an enforceable contract that can go to court. Sometimes when you deliver a purchase order to another company for supplies or services, that purchase order is going to be a contract. You're agreeing to pay for the supplies. So a lot of that preliminary paperwork, the purchase order, the invoice, you put those together and there's going to be an agreement somewhere. Obviously, there are situations where two people sit down and they actually formally draw out a contract and hopefully have their attorneys either prepare or review the contract. That's going to be a contract as well. Sometimes when you're communicating with, say, a business partner by email and telling them what you'll do and what you won't do, and you're exchanging ideas and coming back and forth, a lot of times you put all those emails together and the court will say, there's a contract there. So courts have their unique way of understanding and interpreting agreements. First of all, they're just going to look at the plain language of the agreement and figure out if it makes sense. Then they're going to look and see, well, is it ambiguous? If you read this contract, could it be taken more than one way? Is it vague? If you read this, do you really know what it means? And whenever there's an ambiguity or unclarity about the verbiage of a contract, they're going to use their tools. They're going to look primarily, I think, to the way the contracting parties behaved. They always look at behavior. And if you think about that, if you have a family, kids or parents, you learned really quick that you watch what your parents are doing more than what they're saying. And it's the same way in business litigation. The courts are going to watch what the people were doing when there's any unclarity about what they were saying. Other tools, there are a lot of Latin phrases that they'll fall back on. But by that point, when they're falling back on the Latin phrases, you've lost control of the situation. So if you're sued for breaching a contract or someone's accusing you of breaching the contract, how are you going to defend yourself? Well, I would say the first thing you're going to do is you're going to say, I performed my obligation under the contract. I performed to the best of my ability. A variation of that is I was ready, willing, and able to perform, but the other party did something or put me in a place where I was not able to perform. So if you're sued for breaching a contract or someone's accusing you of breaching a contract, how are you going to defend yourself? Well, first and foremost, you're going to say, possibly, well, there wasn't really an agreement there, to perform. If you know that there's an agreement, you're going to say, I performed my responsibility under the agreement. I keep my promises. I performed my agreement. If you didn't perform your agreement, there's going to be a reason why you didn't perform it. And it's probably because the other side breached first or they did something to prevent you, and you're going to raise that. In addition, you might say, well, the other side didn't mitigate their damages. Mitigate is one of those words we don't use in ordinary conversation, but basically it means that they just sat on their ass, and the damages that they're claiming flow primarily from them not doing anything to help themselves. Those are some examples. A lot of times you see a situation where there is an agreement, but it was waived, or the course of performance was that nobody really regarded that obligation as being important, and so we call that waiver. Another great Latin word, estoppel, that they said don't worry about it, or did or said something that caused you to believe that you didn't need to worry about that provision, and you just moved forward. So how can businesses protect themselves from future contract disputes? I would say first and foremost, you've got to be crystal clear. And this is when it really helps to have an attorney to help you crystallize and be precise about what the agreement is. There are some people in my life that say I'm very annoying because I ask a lot of questions. You need somebody in your life who's asking a lot of questions and maybe even posing some hypothetical scenarios so that you really think and you get, I don't want to say disciplined, but someone in the deal's got to be disciplined. Your attorney's got to be disciplined enough to drill down and be precise in what the agreement is. And so in talking about how to prevent future contract disputes, first and foremost, based on my experience, you really need to have a trained business attorney either drafting or at least reviewing your contracts. You need a partner in this, and I see it so many times. And you know where I see it the most is in business purchases. People come together, sometimes with the assistance of a broker, sometimes without. They slap together an agreement. They haven't really thought through where the trouble spots are in a business purchase agreement. And there are trouble spots. And they save money by not getting an attorney involved. And then 6 months later, it blows up. There's a lot of misunderstandings, some of it innocent, some of it not innocent. And they go to an attorney to help resolve, one side or the other goes to an attorney to help them resolve the mess. And I guarantee you it costs 10, 20 times more to extricate themselves from that mess than it would have cost to just have the attorney put the thing together correctly in the first instance. And so, number one, to prevent future disputes is to go to an attorney. One of the things the attorney will do for you, which we've talked about, is help you be precise and drill down to what the actual agreement is, the time frame for performing, who's going to go in what order, all those things that help an agreement come together beautifully, like a dance. And so they'll help you be precise. They'll help you sequence the understanding. They'll help you know when you're in the red or when you're in the green, when you've crossed the line, when you haven't crossed the line, so everybody knows when performance is happening and what that looks like and when it's not happening. And so that's the main thing to prevent future contract disputes. So if you have questions about contract disputes and especially how to resolve those disputes, please give us a call at the Sierra Crest Business Law Group.